this before.
Okay, shall we start? Okay, this will be our last IEP class, and it will be on the topic of breach of confidence. From an exam point of view, every year it's there usually. And if you were to look at the past year questions, they tend to be examined as an essay question. So if you were to look at the handout that I gave you today itself, and you find that practically every year there will be a question of that. And there are of course two ways of how you can examine. One is where the slant will be in relation to breach of confidence, where we want to see how it could be used to protecting personal information or private information, right? Protection of privacy, that's one angle. This of course is the main one. The other would be of course the more traditional way of using BOC, that is to protecting maybe trade secrets. This is something which really is the original purpose of a breach of confidence, protecting confidential information, trade secrets, concrete club. But if you look at the past 10 years, not a single time it has been tested on trade secrets. So that would not be our focus for the class. But in the course of your revision, your own personal preparation, of course you want to read through the notes and you will find that Concorde and Clark provides 3 conditions, and if the 3 conditions are satisfied, then you can sue for the unauthorized use of the confidential information. Right? So that part I leave to you now to prepare for. My focus tonight will be on more of 3-star of how we use BOC to protecting personal information. Okay? Now, of course, there's still a third way as to how you examine, and it's not very common. And this would be the question that was examined. Question 9, 2015 Zone 8, for instance. So you look at the third question, right? Question 9, 2015 Zone 8. We talked about how there's no need to introduce a thought of unfair competition. So essentially it's that, it's a question on unfair competition. But then you can see how in this question they go on to mention how the actions of BOC and passing off are more than adequate. So therefore, just to make it very thorough in my overview now of the exam focus, BOC can be linked up now with, of course, unfair competition. And of course, once you talk about unfair competition, it could then be also where we need to know about passing off. And so if I have time afterwards, which I should have, I will also cover this as well. So I've got one star here. Okay? So I think in that sense, you can see how these are the 3 possible ways of how you may want to prepare for the exam. Insofar as personal information is concerned, of course it could be where it's problem, or it could be essay. And I think you can quickly see on the summary page, the first page, how essay is the main focus. So this is also our focus for tonight as well. So the parts underlined is what I'll cover tonight. But before I begin, also, I want to just zoom in further to talk about this essay question and the different possible ways of how it can be examined, which will be in essence what we'll cover in our answer guide. Where, for instance, you have several themes. One is, of course, where they want to ask you whether is BOC effective in protecting privacy. So you know, of course, that what has happened is how we had, from the case of Campbell and MGN, where we had used the laws on confidentiality, where in the case of Campbell, it had then been expanded, what I call the expanded or modern BOC, to protecting privacy. And it becomes known as the law on misuse of private information, the 2-part test. And so, and over the past 10, 15 years, we have used this 2-part test this misuse of private information is within BOC to protecting privacy. And so this is the question now, whether or not actually is it effective and has been proven to be so. And so this requires us to look at the cases, put the law down, and then to see how whether BOC has been proven effective over the years. This used to be actually the more older type questions. What I think is more likely to get is this second type of question, related no doubt, but with a slight shift of focus, in that not so much as whether is BOC effective, but rather is BOC appropriate, right, in protecting or to protect privacy. Should we be using BOC to be protecting privacy? And the reason why this comes up is because you find that BOC at the end of the day is meant to be confidentiality. And so we do know that whilst what might be personal could be confidential, but yet you find that these are two separate notions or concepts, and being different concepts, why are we then using laws of confidentiality to protecting privacy? It may not be appropriate, right? And so there are cases, for example, afterwards you look at the case of Google and Vidal, one other recent case by the Supreme Court called PJS, where these are cases that has highlighted that confidentiality and privacy are two separate notions. And so we should be using different laws, so to speak. So maybe BOC is not appropriate, right? And so right now you find that we've begun to call for a recognition of this current law on misuse of private information to be recognized as a tort. That means what started off from the equitable BOC has now evolved to become unto itself a branch of law, which is the tort of privacy. And in that sense, this is also part of what I want to put down now as a tree, okay? And linked also, of course, to all these earlier themes, in whether or not should we have a tort of privacy, right? The recognition of a tort of privacy, and a question mark. Now, as I mentioned, we have begun to see cases recognizing misuse of private information to be a tort. But that is to be discussed from an academic point of view, whether or not should we recognize that to be a tort of privacy, is it appropriate? Right? Now, the reason why this is an issue that we arrive or we discuss is because if privacy is something to be really so important, then should we not, instead of leaving it to BOC or leaving it to privacy tort, should we not have an actual statute, or rather, have a privacy code that sets up now the core obligations of parties and the expectations of someone in relation to his private matters. So we are in some sense saying that statute is far more able to be comprehensive and to safeguard a fundamental right that we have, which is on personal information. So when I put these two down, BOC and privacy, I put it here down, this other sub-point, which is whether is common law appropriate. Now both BOC and privacy, or rather in tort, is still common law, am I correct? Whether you call it laws of confidentiality, it's common law. Tort of privacy is still common law. And so that's my point. When we discuss 2 and 3, they are separate. But while separate, there's still one constant similarity in that both are common law. And so as part of a discussion is common law effective? Right? Now, the thing is, I have no idea of how the exam focus could be like. And in some sense, the main content will be the same. Obviously, you talk about Coco and Clark, talk about Tinta, Hello, Campbell, 2-part test, of course. So in that sense, about maybe 60% of your answer will be generic, regardless of which theme you get. But I would think that it would be good if you are able to read the question carefully. And so take some time when you take the exams to read the question carefully to see if you can sort of get a sense of what is it that the examiner really wants to ask you. And then with what they want you to, what they're asking you, you then make sure you write accordingly to answer the question. Right? And each of these, as you can see on the board now, is similar, but there's a slant to it that is also different. The answer guide I have will cover all these things, But of course, again, because I don't know what they could ask you, the points are arranged in different manner, right? So it may be at the end of the next session, or when you go back home and you sort of consolidate all that you have learned, it may be that there are 20 points, let's say, okay? Of the 20 points, you will then, maybe for this year's question, use only 10 of those 20 points, or use 12, or whatever, right? So you have to be discerning in a sense, and to map out for yourself the key points, and then be flexible on exam day to use the points accordingly. That is really, by the way, a strategy you use for not just IP or this topic, any essay question. So that you don't get caught out in the common comment made by an examiner where they always say that, oh, students are regurgitating. And they or you regurgitate because why? You memorize an answer, you see the topic, you put down the answer. Like you prepare an answer on BOC, you see BOC essay, you put down the answer. But BOC within it can be with different themes. And so that's why you cannot be really memorizing something, put it all down mechanically or rigidly without flexibility in your answer. Okay? So with this now, I think we have a rough idea of what or how BOC to be examined. And this, of course, for the essay question. Now, for the problem one, this will be what you see also here, where the last time it came out, I think, was 2013. So quite a few years ago. Is there a possibility it could be examined again as problem? Of course. But I think it's problem, you will get it, it's easy. In fact, if you are able to write an essay answer, being one that requires more knowledge and information, for sure you can use the essay material to answer a problem. But let's just run through this very quickly now, so I can give you a big picture of how it works. This particular question 7, 2013 problem question, is not just on BOC, it's also mixed up with copyright. I'm not so sure whether did Joanna do this with you for copyright? Did she? No, well, okay, let's read this together. So Tom is an actor, published memoirs, describing in detail his career and various actresses with whom he has worked. In particular, one of them being his wife. And the memoirs portrays Tom to be a model citizen who upholds family values. And of course, then we have Simon, who assists him to write the book or autobiography. And Simon has put the various chapters in the book into a logical order and even corrected Tom's grammar and spelling. And the copyright in the book was assigned to Publishers Marlowe Press plc. Now, you see the first paragraph and the first line, you know the issue of copyright, of course. But tell me now, what do you think is the issue about Simon? Why would you think that you're given information about Simon here? The possibility of co-ownership, correct, okay? So Simon will say, well, I was responsible to do all these things and I can be a co-owner. This is an argument, of course, right? But otherwise, insofar as the copyright subsistence, I think it's quite clear. Obviously, it's original, am I correct? Because this is something that is about his life, his written it, and moreover, we are told that the copyright is assigned now to Marlowe Press. So copyright is not a big issue, but something you can discuss at the same time. We're reading further now. Then Tom has an exclusive cocktail party to launch his book. He has agreed that this FAB magazine will have exclusive rights to the photographs, and those who were to attend at night had to sign an agreement to keep these things confidential. You see that paragraph, what case comes to mind? About the exclusive photographs given to different magazines. The case of Douglas and Hello, correct, okay? So straight away, you know that this can't be just copyright, it has this other issue of Douglas and Hello. So reading further down. And during the evening, Tom talks too much about the time he became an actor and revealed about some of his shady past, about how he has a criminal record. He talks about the names of various actresses with unknown to his wife he had affairs with. So now these are his, you can see, personal, private information, which is not in the book obviously, which is now talking about, right? And so he's now divulging personal, private information. And unknown to Tom, a reporter who was present secretly recorded the conversation on a mobile phone. Now again, when you see this secret recording, you find it very similar to some of your other corporate questions you have seen, right? When someone gives a speech, a reporter records it, am I correct? The same thing now. You want to be able to also argue the question of whether or not is there copyright in this conversation. Now, when I say that this is a copyright question, the first part, of course, was we discussed copyright and relation to the co-authorship. I agree. But this is now another issue of copyright. This is now the copyright in relation to the conversations. You tell me now, this is what you see so far. This is now someone speaking, right, talk. And then Una, the reporter, records. Would you think that copyright may arise? Based on what you understand or remember of copyright so far? I'm now not talking about a book, I'm not talking about a conversation. Is there copyright now in this conversation? Yes. This would be possibly original literary work. Literary work is anything written, spoken, right? Or sung. So when you speak on something, it could be copyrighted. But of course, speaking it itself is not enough. There's one requirement, which is speaking it, although it's literary work, won't be enough because you must also show fixation or tangibility. You've been studying that the past few days. Okay. And here, the requirement of tangibility or fixation is satisfied by way of the recording. Am I correct? Does it matter it's recorded by someone else? No. Does it matter it's secretly without permission? No. So that's it. So the recording itself gives rise to copyright. However, now, let me now ask you this question. Whose copyright is this? Is it Tom's copyright or Una's copyright? So it's recording. It's literary work. It's original, obviously. But who is the owner of the copyright? Tom, the speaker, or Una, the recorder? Use common sense, maybe. Okay, common sense will incline the answer to Tom because it will be funny that if this is my speech, then I don't get the copyright, but you do. Am I correct? So when you say Tom, you are not wrong. But not wrong doesn't mean that you're right either. So the best is to say both, actually. Tom owns a copyright in the form of section 11A of the CDPA, which is the original literary work. He's a speaker, he's now captured, fixated, so there is that copyright to him or that. And it originated from him, am I correct? For sure, it's him. Then when I say both, Una therefore also has copyright. Tell me now, what copyright does Una have or has? Now, co-ownership is a good thought, but if you look at section 10 of the CDPA, when they talk about co-ownership, it must be a case of where the co-author or co-owner has also contributed to the originality. But no, it's just a recording, am I correct? You press a button. You appreciate that there's nothing original, right, about what Una has done. If Una has edited the conversation and produced a script or whatever, summary of the talk, then I agree. Then maybe you can say co-owner of the book perhaps. But notice it was a recording, it's a mechanical tool as such. There's no creativity involved in a sense. What copyright would Una have when you record something? And I just give you the answer actually. When you record something, you get copyright in the sound recording, right? Because as to what amounts to copyright work, it's not just literary, dramatic, musical, artistic works. It's also in 11B, which 172. It says that sound recording may also be copyrighted, am I correct? And I mentioned this to you during lectures, right? That when we talk about sound recording, there's no requirement for the sound recording to be original. Because technically speaking, no sound recording is quote-unquote original per se. You're always recording someone else. That's why in the Wisdom of Parliament, when they talk about copyright work for sound recording, it's 1/2, I believe, they never use the word original. Original was used for LDME, literary work, for instance. So that's it now. So to give you a quick revision or summary of copyright, there are two copyrights that arise. When Una records, the recording itself gives unto herself a sound recording and gives for Tom original literary work. Okay? So this is the discussion of copyright. Now reading further now. Tom now discovers that Daily Grudge proposes to publish an article based on Una's recording. Now, of course, this Una is not just anyone, it's a reporter working for Daily Grudge. And you see this all the time for many of our IP questions. When there's someone working for another, what issue is this? ownership, am I correct? Ownership. So Tom, for example, who will Tom sue? Will Tom be suing Daily Grudge or will Tom sue Una, for instance, right? The claim for copyright, who will get the copyright claim? Is it the Daily Grudge who says they are the copyright owner, or is it Una, right? Obviously, if you are a reporter working for someone and it's a work created in the course of employment, therefore the copyright belongs to the Daily Grudge. Which means, as we discuss copyright, yes, I did say that Una is the owner. That's not wrong because she's the one who created the work, but actually she's the author. The owner is Daily Grudge. You can see or remember now copyright has a distinction between ownership and authorship. Authorship is Una, no doubt, in the sound recording. But ownership is the employer. Why? Because this is a work created in the course of employment. Okay? Right, so this is actually all revision tonight, also for copyright, and to show you how it will link up with BOC. Now, so that's the part now. And anyway, so this article is to be published by Daily Grudge. He discovers will talk about his criminal records, his trading past, his affairs, so on and so forth. Placing these details alongside, alongside lengthy extracts from his memoirs. What is the relevance of how the conversation will now be published in a newspaper, but alongside his memoirs? And the phrase lengthy extracts. What issue is this? Very good infringement. It's like, okay, even if you have to say all this because you are the one who recorded this and you're a reporter, you report current events, current affairs, sure. But why must you be placing alongside the book? Am I correct? So the issue of infringement will also arise. Okay, so that's really on copyright. But back now to our topic tonight, which is on breach of confidence. As far as Tom is concerned, apart from the issue of infringement of copyright, the more fundamental issue is this. You look at the question carefully. At this moment, has the article been published? Not yet. He wants to seek for an injunction to stop the publication. So what can he do to argue it should be stopped? He will argue right to privacy. He will argue this is personal information. How can you simply publish without my consent? I have a reasonable expectation of privacy, Article 8. Of course, the whole answer will require a balance. It's a two-part test. Whilst Tom will argue Article 8, Daily Grudge or Una will argue Article 8 versus 10. 10 being the right to freedom of speech. Okay? And then we have to talk about a balancing test to see whether or not is it 8 or 10 that will prevail. Let me just try to test you now. Based on what you see so far, would it be more of Article 8 or 10? Now, of course, in your answer, you may even say that, there's no article, there's no Article 8, and then therefore it can be published. If you conclude there's no Article 8, then the answer is very premature, it ends with you. You have to somehow conclude that Article 8 is engaged. Then you can discuss Article 10, am I correct? It's a two-part test. Once you fail the first part, once you say that Article 8 is not engaged, there's no right to privacy, then okay, then no need to do this Article 10. So your answer is not so nice, not so good in terms of discussion. So somehow in your exam answer, you will be concluding Article 8 is engaged. There is a right to privacy. But although you have a right to privacy, and I think you have, am I correct? But the more important thing is what about the right to publication? But based on what you understand so far in your studies of revision, would you think Article 10 will prevail or Article 8? More of which one? 10. Okay, why? I mean, there's no wrong answer, it's a criminal record, so something that the public would have right to know. Not wrong, but you would have to substantiate that. Which is, I may be with a criminal record, but that does not mean to say you should black it all over to other people, am I correct? So you may not be wrong, but something more that justifies for this criminal record to be publicized. Okay, part of it is celebrity, a bit more. And you may think of, for example, the case of Campbell, am I correct? And Campbell, the issue of drug addiction was something the court said that the newspaper can publish. But actually, the reason why they said it was because of something else. Why was it in Campbell? where the court was so in favor of the publication, despite granting her Article 8, but Article 10 still prevailed. Why? Again, Campbell being a drug addict is a personal thing. That does not make you a right to know my affairs. No doubt, because of celebrity, that is something that may erode my privacy, I agree. But in Campbell, there's something else, which is also here, by the way. In your first paragraph, the answer is there. In the first paragraph, what do we told? That's right. The book that he has written talks how he is a model citizen upholding family values. And it's exactly it. The press has a right to clarify their truth. Because if you are having affairs, if you have a shady past, obviously now you have utilized the press or a book to paint a false picture. The newspaper has a right also, isn't it, to communicate what is the truth to the public. And so overall, I would agree, Article 10 will prevail, but you can't just conclude that based on the last paragraph. Look at the whole question, in particular the first paragraph. Okay? Now, as I now go through with you this answer in this manner, you should also realize therefore it's a better exam technique when you read the question, unlike keywords, highlight it, and know where to use it. Okay? Then make sure that your answer should use it. And actually, you can only conclude Article 10, in my opinion, if you were to refer to the first paragraph. Just like Campbell. Campbell had used the press to advantage. Campbell told the press, I'm not a drug addict. And moreover, portray herself to be this model celebrity. And the court says no, then therefore we allow the press to correct that truth. Exactly what we have here as well. And so that's it, end of this answer. Okay? So I'm just talking aloud, but my point is to be able to allow you to see how copyright and VOC can come up with one question, and more or less in this kind of situation, what information to use for what discussion. Okay? I think you can write this answer on your own. I suggest you, as a practice, to also do that as a practice, to do an assignment of this, to sort of organize your thoughts. But otherwise, right, again, my main purpose tonight is to look at these two things on the board, which is the question on personal information, the essay question, and all these are three themes. If I have time afterwards, which I might have, I will then look at unfair competition and pass it off, and then link it to POC. Okay? So this allows to revise also pass it off, and also talk about unfair competition, which I have not yet really touched on so far. Okay, any questions? Now, in the possible event as well that we have no time, then this unfair competition and pass it off thing you can read on your own. I think the previous class I gave you a handout, right? Look at the handout that was in the previous class. If not, you've got today, you have time to go through that as well. Okay? So let's start off with the answer. You can look at page 2 now of the answer guide. So, is the law on VOC appropriate to protect privacy, and is the law been effective? That was the first point I put on the board. It's now here, right? The answer. And I'm now making reference to this Equality and Human Rights Commission research report that was published in 2011. In your notes, which by the way you can do revise through the notes because the notes are quite comprehensive. In your notes, this particular report was mentioned with the conclusion, which I'm now extracting and reproducing here. Just that here is where I'm expanding more, okay, in a sense. Where you look at the very first paragraph, we set out how the general picture is this, where we are submitting or arguing that the current law on privacy, I put P at the circle, okay? The current law on privacy, at least according to the report, which we can either agree or disagree, but now let's agree, okay? They say that it is weak, it is piecemeal, as well as it's fractured, right? Weak, we understand that, okay? Not very strong. And in some sense, if you think about it now, it's true. If you have to rely on your privacy rights based on common law, it's weak compared to if it is by statute, isn't it? So that's straight away a correct thing we can appreciate. Piecemeal, also true. 15 years ago, there's no such thing as privacy. You may recall this infamous case of K and Robertson. In K and Robertson, this was a 1980 case, so about 20 over years ago actually, where that case was about this actor who was involved in an accident. A picture of him was taken, and he tried to sue, and he wasn't successful, right, on the issue of privacy. Now, he was successful later for something else, but on privacy, the court says what? There's no such thing as protection of privacy. And so, we can see how the law back then had no privacy, but today, of course, we've evolved to say yes. But my point is an evolution, and that's why it's very piecemeal. And even the evolution now, we have your stage 1, stage 2, Article 8, Article 10. Then over the years now, we add on how Article 10 works, we add on how Article 10 works. So this piecemeal development is not very good because we don't really have a very fully developed law that one can rely on. We have to go along. When there's a problem, we add one more principle. When there's a problem, we add one more principle. That's not a very good way to protecting privacy. Okay? Although I must say this now, from the beginning, this piecemeal development, although I can criticize it today as not very good, isn't this actually the very hallmark of a common law system? Common law is like that. Common law is evolving in that when there is a problem, we respond accordingly to the problem. So you get justice for your case. Yes, before that there's no such law, but it's because it's common law. Common law don't create law, right? So to some extent, the current problem we are in is precisely because it's common law. This is also what I said just now in my answer guide in the intro, where is using common law the best way forward. And common law is perpetuating this kind of problem, so to speak. So maybe statute is a better way forward. Okay? So it's weak, it's piecemeal, it's fractured. Fractured as in how we have different laws that we rely on to protect different aspects of privacy. So for example, even in Singapore, for example, we know this, right? If we have misused your name, your phone number, there's a PDPA that we rely on. But if it's considering other things, then it's this other law. It's other things, it's that other law, you know. And so we have different situations that would be a concern for privacy, and then we use different laws to respond. So therefore, it's very fractured, and it could be relatively gaps, right? Fractured, and therefore there are gaps. The one will fall within. And so that's why overall, VOC might not be very effective. Now, I'm just giving you an introduction of what the Commission is saying, and that's found in your first paragraph. Okay, and in fact, they want to say this also, that the right to privacy is difficult, right? It's difficult for individuals. It's difficult for individuals to understand. And this, I think, is true because obviously it's a very technical area of law dealing with, is there Article 8, Article 10, right? What are the factors for both these stages of test? And so an individual may not find it very easy to understand what these rights are. Right? Last but not least, right, the fifth point, and all this will expand more afterwards as well, is the fact that there is a growing demand of information by the government. And so there is an erosion, not a good now, erosion of privacy, because of the demand of information by the government. And I think one good illustration is what we're now seeing even in Singapore or in the world over in relation to the Facebook issue, right? Where there was a leak of information. And so now we're trying to get Facebook to take steps to prevent that. Now, if you think about it now, on one hand, it is the way of the governments trying to protect privacy. But actually it's not, you know. It's also their way of trying to make sure that they are able to get access to information which otherwise they would not be able to. I read this somewhere in this newspaper. You know, in the whole world, which country is the one that's made the most number of requests to Facebook to ask for information, but were denied? Singapore. The smallest country, one of the smaller countries in the world. Way smaller than America, obviously. But it's the number one country that's made the most number of requests to Facebook asking for information. Why? Because, and you know Singapore, like, someone says something bad, you want to find out, hey, who said it, right? And Facebook, what? You can create a fake account, you don't know who you are. We don't know, but Facebook will know, am I correct? And understandably, because they'll say, terrorism, we have to find out. Anti-money laundering, we have to find out. Fake news, we have to find out. Information. That's the thing, is it? Governments today want information. They will say to you, you must protect information. Correct. Protect it so that they get it all for themselves. And this is my point here now, that therefore there's a greater erosion, a very serious erosion of privacy because of the growing demand of information by the governments. If you are in the banking sector, for example, you notice that increasingly compliance is a big thing. Where banks, in the past, you open a bank account one day, a few hours. Today, there are instances where it will take a few days to approve a bank account. They will find out where did the money come from? What is the proof that the money came from that particular source? They will trace all this, right? So it's not so easy anymore. And they will find out, declare this, declare that. So here is a case of where they are collecting a lot of information from individuals. It's all mandatory, all compulsory. You want a bank account? It's not a company, Accra, you must declare all these things. And so, given that, our privacy is eroded. And that's exactly my point. That is common law a good way forward? Or for now, is BOC a correct law to use? Are we okay? Now, in some sense, you have the answer now on the board already anyway, but it's really more of a first paragraph to sort of give you an idea of how BOC might not be so effective, right? Now then, in your second paragraph, we look at more specifically the failure of BOC. Okay, so the second paragraph, or second heading, is failure of BOC. But I put BOC / CL / common law. So I discussed at the same time. The failure of BOC is concurrently also typifying the failure of common law. And so at the end of the answer afterwards, the main thing that we want to really ask for is for perhaps some measure of statutory interpretation to come in to ensure that statute can protect our rights. Now, so the first reason, okay, so in the notes now, our answer guide, page 2, first and foremost, there's a danger that because of the high cost of civil litigation and the fact that legal aid is rarely available for private actions, that any new tort of privacy, and now we refer to tort of privacy, but the same is true for even BOC, will only be accessible to the wealthy. So the first thing is that such laws or such protection from BOC or from common law will only be available or is only available to the rich. Now, as I make this point, of course, you want to be able to expand further on this point. How is it that protection is only available to the wealthy? And that's because you find that what we see here briefly, legal aid is not generally available. And moreover, an actual action for BOC is obviously a lengthy trial. The people who tend to, for example, misuse of privacy are newspapers, am I correct? Or even the police or the governments. They will have money to take the case all the way. Right? Newspaper and magazine. For them, it's a commercial concern. You are the individual. As an individual, would you have money now to go all the way to court? To get investigators to investigate, to get a good lawyer to represent you, to talk about your two-part test. It's not easy. In fact, most of our cases that we have currently on BOC are all cases of what? Celebrities. Douglas and Hello, Campbell, all those cases were cases involving mainly, of course there are some that were individuals, but they're all mainly celebrities. And we know why, because they have money to want to argue for their privacy to be protected. So in some sense, we have them to thank for, very good. We thank these people because they have the money to sue, and now that's why by suing and won the case, we now can rely on the same laws. That's the thing, is it? Why is it that the laws are only determined because the rich can afford to make those laws? Which means to say now that as individuals, our laws are, or our protection is a bit weak in a sense. And even if, now that the laws are there, but if you want to really sue, my same point, that we might not have the funds to pursue an action all the way against a giant corporation, against newspaper. And so for that reason, that's why we say it's not so good. Now, on the other hand, just to briefly compare now with statute. Easy about statute, am I correct? Section 1 says this, you have done the wrong, that's it, open and shut. Common law is also arguable. It's very fluid. And so that's why this is really a point that is detrimental and how BOC/common law is failing. Number 2, the second reason is that it is unclear as to what sort of compensation will be available. Okay? So the compensation and the uncertainty of what you will get. If I ask you, what branch of law is BOC under? Would you know the answer? Is BOC contractual? Your right to keeping information confidential or private, is it contractual? The answer is no. In your first page of your notes, and throughout the whole notes as well, we emphasize this, that BOC is actually in origin an equitable right, or equitable law, so to speak, right? And you know, of course, from contract law days, or studying law so far, that equitable laws do not automatically give you damages as compensation. Damages is only discretionary. And so no problem. The point now is this. The BOC is a law we use for privacy. Then there's a whole huge question mark on what then would be the available compensation. You may not get sufficient compensation, if at all, okay? Because it's only an equitable breach. Equitable breach don't result automatically in financial compensation. So that's why it's a problem, okay? That's number 2. Number 3 is that this judicial activism, and a phrase that we use here, judicial activism, refers to, of course, the role of judges, will only serve to make the law more fragmented and undermine the case for improved statutory regulation. So I'll say this here now, in this manner, that judicial activism is not desirable. And the reason why I say so is because it makes the law more fragmented. Makes the law more fragmented than what it is currently. It creates more uncertainty. If you want to now even argue further here, there's now also more uncertainty. At this juncture, for point 3, I think it's good for us now to evaluate laws, right? Examine case laws, and then to show how it should be. So I'm going to start here now. This part of the answer is where we want to look at cases. Not just simply making a point, but without actual support of what we're saying. So in point 3, if we say that judicial activism is not good, why is it not good? Let's now look at case laws, okay? And so in your notes now, you find that we have a list of cases. These are the key ones which I've highlighted. Murray and Big Pictures, Hanover, Maudsley, Brook and Roll. This will be what we cover in lectures. But for today, I'll just go through very quickly the key points for us to reinforce point 3. For us to show how judicial activism is not good in a sense. Okay? So for example, we want to talk about how in Maudsley, Murray in some sense is a good case because it's a case that provides personal factors. Factors to Article 8. For revision, on your own, just go back to Murray and memorize the factors. Where what is useful of Murray is that the court provided a list of factors as to when is it that your expectation of privacy may arise. And I think they put down 7 points. So you put down 7 points now, right? But again, it's my point. Why is it that we need to wait for a case to come with the factors to then tell us when is it that we have privacy? Should we not again have a statute to say these are the criteria to be satisfied, these are the factors or guidelines to consider? But no, you have to wait for a case. Murray only came much later, so a case has now come along, so it's now good. But the fact is that if there's no such case, then there will be no such principle. And the point is that it makes the law very fragmented. Also, on a similar point, the next case is the case of handover. And I think it's even a better illustration, where you recall how in handover we have three judgments, right? Number 1, number 2, and number 3. You can again go through your notes now for all 3 handover cases. But as you go through now the handover cases, you recall that the first case was the only one where was successful. Okay, so here was a successful action bought by Mrs. Caroline. But yet in the next 2 cases where she failed, not successful. Okay, next 2 cases was where she was not successful. And so my point is exactly this, right? That when you look at how we have judges interpreting privacy, the way they interpret privacy is very subjective. So if you want to like even end here somewhere, where uncertainty, I put here now, the subjective interpretation of judges, or by judges. And it's illustrated by these cases. Okay. Let me give a very simple example. Maybe I just backtrack to Murray again also. Murray, you recall, concerned 17-month toddler, right? This was J.K. Rowling's son, this toddler being pushed on a pram, and a picture of the toddler was taken. You tell me now, would you think that a 17-month toddler ought to have a reasonable expectation of privacy? Would Article 8 be engaged? And the answer is, in your opinion, for you. Is there any intrusion of privacy? For him? And the answer is, no. Yes? Why yes?
Because he's the son.
Okay. But how has his privacy been intruded? Reasonable expectation of privacy. In fact, can I say this precisely? Because you're a son of celebrity, then you have lesser expectation of privacy. Just as celebrities, we understand it comes with the position you're in. Same is true, right, for the family. But it's like, I mean, it's not fair, I know it's not fair, but it's how it is. That if you are rich and famous, for sure you expose the children to all these other things. So why are you now saying that you should right to sue? Would that be your view? Why do you say no?
He's still so young, and he's not a celebrity himself.
Okay. Yeah.
So what kind of news will be? I mean, yeah, he doesn't have any.
Okay, so he's young and therefore would appreciate the photograph taken to be intruding on his privacy.
At that point in time.
At that point, okay, fine. So we have no, yes,
Yes and no.
yes and no. Don't know. Is it what? Only 4 person, 4 different answer. Yes and no, yes, no, don't know. Okay. So when we say the law is fragmented, when we say the law is uncertain, when we say the law is subjective, it's true. In fact, look at Murray. If you really follow the way the case came up, at the first instance, the judge would say that there is no expectation of privacy. You're a kid. What would a kid expect? Would a kid cry when his picture is taken? Would he feel distressed? No. Now, you and I, maybe, am I correct? You and I, because we can be a private person. But no, this is a toddler who has no sense of any intrusion of privacy. And so, why should he be given rights at the moment, at the stage? That was what was said by the assistants. But this was not agreed upon when they went on appeal. The Court of Appeal said that no, that although yes, this could be a child or young child, might not appreciate what's happening around him or her, but there could be perhaps adverse long-term consequences. So maybe not now, but in the future. Moreover, not just that, if we allow a reporter to take a picture of him when he was young, they will think it's okay, and they will keep on taking pictures of him throughout his whole life. Now, will that have an adverse effect on him? Maybe. And moreover, the court says, whilst he may be okay, but the mother is not okay with it. And you recall this, we discussed this, that the mother is a very private person, has never used the children in any way, and would have brought them up to have a private life. And if that's the mother's expectation, we sort of like share that with the child, and that's why other people was engaged. Now, leaving aside the conclusion, but my point is, you can clearly see how the judges at first instance and at court of appeal have different views. Then now, handover. Again, number one, number two, number three, the judges had different views. And that's why now they have different conclusions now, okay? You may recall, of course, one of the case now, I think it was number, I also forgot, so too many cases. The third one, okay? The third one was concerning how this was a picture of Princess Caroline's private home appearing in the newspaper. Right? So a picture, the number three, the last one, a picture of a house was taken. And this was an article that was commenting on the homes of rich and famous, and how the rich and famous would sometimes rent out their homes to holidaymakers to make money. And so they featured a list of houses, and Princess Caroline's house was also featured. She was upset, of course. She said, why are you featuring my house without getting my consent? Which in a way is true. Can you imagine now, someone take a picture of your house now, newspaper. If your house is very nice, then maybe you're proud of it. But even so, if it's very nice, you don't like it, am I correct? It's an intrusion. I think a picture of our house is very private. And now that picture is taken and it appeared. So now everybody knows now where the house is, or how it looks like, am I correct? And so that's why she sued. But were you successful? Would you know? Would you recall? Anyway, the court concluded, the court said that she was not successful. And of course, it's because there's a link between the article and the photograph. The article was talking about house owners renting out their houses. And so, among the list of houses, your house was one of those. So therefore, we can feature a house. There's a right to publish. Okay. Now, if I explain it like this, you may understand. Yeah, okay, what? But that's not true. For example, what if now I do an article on suntan lotion? Then take a picture of it at the beach and publish now in the banner, a big picture. Now, you don't like yourself, with a picture taken on the beach, maybe not in a bikini, for example. You will sue, No. I'm publishing this why? I'm doing a suntan lotion. You're at the beach now, suntanning, you use lotion, right? So therefore, there's a link. It's very subjective. You can always show a link to erode someone's privacy. For example, now, if I take a picture of all of you right now and put in IT's Facebook, would you like it? Maybe. But, or this paper, you may not have, know. You say, hey, why not? We are law school, you're law student, that's it. Right to publish. We can always find a ground, if you want to justify publication. And the thing is this, it's very circumstantial on a case-to-case basis. And it's like, the law is very weak, The law is very fractured, very fragmented, it's very subjective, it's very uncertain. There's no real concrete protection. If I may, I want to add this phrase as well here at the top, okay? There's no real concrete protection. We don't know for certain exactly when our rights will be protected. We don't know when our rights will be protected. So I think these are two cases that will be useful. And then again, of course, we have the case of rock and roll. I'll just jump on one case now and move to the next case, rock and roll. Rock and roll is also another case, but for an extreme position. Rock and roll was a case where there was a successful action. But this was a case of someone who he was a celebrity. He married, rather he was the ex-husband of Kate Winslet. Kate Winslet being the famous actress, ex-husband. And he is the nephew of some rich fellow, Charles Branson, I think. Yeah, that's right, Charles Branson, the Virgin boss, okay? So Charles Branson's nephew, Kate Winslet's ex-husband, so some minor celebrity of sorts. And the point was this, that he was, if you recall the facts now, he was at a party, and it was a posed party, and he had taken off his shirt, I think even his pants as well, and he was just partying. A picture of him was taken, was posted on the person's Facebook page. But of course, that photographer or the person was nice or kind enough in that he was only to the private friends who could view. And there's not too many, obviously, okay? But as you know now, Facebook always changed their privacy settings. And somehow now, when it changed, it went out to the public. Everybody could see, okay? And again, someone found this picture somehow, and it was leaked out. So now this guy now is upset. He says he's now suing because I never consented to my picture being taken and published like this in this manner. In a way, it's true. Am I correct? I can agree it's true. You are half naked, your picture now being circulated. So he sued and was successful. So in a way, it's good to show how there's privacy. But still, my point is that it's very fragmented. Because I'm not arguing, if you decide now to take off your clothes at a party where there are people who can see you, you run the risk that you'll be photographed. Am I correct? Technically speaking, I can then do with it the way I would. Because whilst you are attending the party, so am I correct? It's that I'm a witness of something. Now, if of course I were to take a private picture of your birthday party when I'm not invited, I can understand. But no one, you are a spectator or participant of the party, as with me. Whatever that you do, I will also be part of as a witness. I'm only putting on my Facebook page what I see. And so, but yet the point is this, he was successful still, and my argument is that it's uncertain. How do we know now? When is it a handover situation where you can't sue? When is it rock and roll where you can sue? Okay. So in that sense, that's why it's very subjective. Then any more cases? I think the best one is Ray PGS. Okay, the last one. So I'm just skipping a few here and there, and just highlight some for you now. Ray PGS. This one a bit tricky. Let me see whether you get the answer right. Ray PGS concerned a 14-year-old boy. And this boy was involved in racial riots. I think he was taking part in it actually, okay? So racial riots. And again, the police was involved, and the police had taken pictures of the racial riots. And the police later decided to name and shame the people. And not in a specific sense to target them, but more of trying to show to the public that this is a bad thing. So the police had used the photograph now, and they appeared now on the newspaper and all that to show how racial rioting is bad, should not be tolerated, they'll take action against you, don't do this ever again, so that when people see it, wow, let's not do it, And so his picture, this 14-year-old boy, had appeared in this paper. And again, the idea by the police was to use it as a deterrent to prevent other people from participating in this kind of racial riots. The parents, of course, didn't like it, and the parents now sued. And amongst other things, they say things like he's a 14-year-old boy. His future could be affected. No doubt he's done something wrong and stupid, but look at his age, look at his future, and look at the implications. Why are you doing this? Are there not other better ways to educate the public than to put a picture of my son without asking for my consent? Which is, in a way, not a bad argument to argue. Bear in mind now, this was a school-going age child. Now, based on brief facts I've given you now, would you think that Article 8 will prevail or Article 10? Your opinion. Do you think we should allow for the photographs of a 14-year-old boy involved in racial rioting to be published or not? Okay, choose one now. Okay. I'll come back to you. Okay, depends on what.
Because the police can say, how do you see?
Of course, yeah. We know this is what they will say. They did say that also. So you know, now when you say depends, you're right. But I'm not saying that based on what you depend, what's the answer? So fair enough, let's take an argument. The police will say private policy, the parent will say intrusion in private life. Okay, so how? So this my point, how do you balance it? How would you, if you are judge, balance this? You choose 8 or 10? You choose 8, huh? Okay, I suppose when you say that it's because of the child's age. Okay. 8. More together. Okay, anyway, we have 3 already, so you're dissenting you, okay? The majority has decided and spoken, Article 8. But the judges didn't agree. In fact, the majority view, I put it here now for you. This is the case which I'll emphasize more afterwards on a different point. The majority view said in the first place there's no Article 8. The minority gave a different view and said yes to Article 8, but although it's Article 8, Article 10 prevails. Either way, it's the same. That if you take the view of the majority, you can publish. You take the view of the minority, you can still publish. Because why? For the minority, they said Article 10 prevails, okay? So in that sense, for now, the route taken, the reasoning provided to arrive at the conclusion was different, but the conclusion was the same, to publish. Clearly going against 3 of the majority's view. I'm just doing all this to underscore how the law is very fragmented. It's too case specific. Now I can understand, I suppose if you were to get your hands on the judgment and you read it, maybe you agree with them. To be fair, what I'm now doing is fair to all of you because I'm merely giving you the brief facts. And also you know me, right? The way I say those facts is to say the manner to get you to give the wrong answer. I know you say that actually. I'm very certain if I present the facts differently, you say something else. But leaving that aside, even if you were to look at the case data and say, yeah, Mr. Trump, you have misled us, you did say all those things. I agree with the majority, so fair enough. But my point still remains in that our right to privacy is dependent on all these nuances, on all the specific facts, on this or that, not just age, the public policy, the fact that he's going to school, the fact that racial riot, the police, there's just so many factors that come to play. And now, if I ask you, when would the law protect your privacy? We don't know. It depends. Now, is that a right place for us to be in? Now, of course, you can argue, but Mr. Trump is not good, it's not bad. It's good because it's flexible. Now, in all that I've said, actually, everything I've said so far can be twisted over to say good. If I ask there's only one thing good, it's flexible. Flexibility is good because why? It can now do justice. But hey, it is flexibility to do justice for the boy or for the family. And flexibility is a double-edged sword. It can turn against you. And worse is this. There are some areas I think we should be flexible. There are some areas we should not be. For example, sentencing. I think sentencing for criminal offense should be flexible. Take into account mitigating factors to reduce the penalty, am I correct? But the issue of the offense, it should not be flexible. Offense should be certain. You know what you do is wrong, means wrong. Not wrong means not wrong, this should be fixed. Sentencing, I agree, should be flexible. Okay, so that's my point. There's some things that should be flexible, but not insofar as a liability, not insofar as the successful action. It should be certain. Okay. Maybe you say, compensation, be flexible. Fair enough, I think we will. How much intrusion was it? How affected were you? Maybe if you're a 14-year-old boy, you laugh it off, you don't care, okay, that's the money, But if you are someone rich and famous, your reputation is now damaged, give you more money. Okay, so this is flexible, I agree. But surely not insofar as the law itself, as the two-part test, which is so uncertain. Now, even though these guys won the case now, okay, these guys won the case, actually leads to her. But still, my point is not that winning the case is good. My point is that winning the cases makes the law more fragmented. Now we don't know when you win, when you lose. Okay. So you want to actually in your essay answer, of course you don't have time now, 45 minutes. But if you can pick a few juicy cases, I've done some for you now. You can go through on your own to see which one you want to use. And use the facts of the case now to highlight or support your point. Okay? You would have time to go through all, but in your notes now, I've given you like 6-7 cases. All are cases you can use to argue toward supporting my point here that this judicial activism is not done. Okay? Any questions? Now, what I've just done, by the way, is all explained more or less in the next 3 paragraphs. Let's read briefly now. So page 2, third last paragraph. So it's all here already. So in case you don't know the phrase your answer, it's all here. In your third last paragraph, it says this. From an examination of the above cases, it is undeniable that the protection of privacy has strengthened. In a way, it's true, because many of those cases, they were successful. Okay, fair enough. With the seemingly appropriate balances struck in upholding, on one hand, freedom of speech and the important role of the press as a public watchdog. Their importance has in some cases also diminished. Moreover, applying the old principles to individual cases has in some cases caused uncertainty or inconsistency. There's also no clear practice, for example, as to what kind of sanctions are appropriate. Next paragraph now. Moreover, the degree of discretion when applying this doctrine of marginal appreciation has been less than consistent. Here's where I talk about BGS, where you have minority, majority, and different views. Okay. The last point, last paragraph, the lack of predictability. Clearly, we can't predict now when is it that you can win the case or lose the case, when you have privacy or no privacy. And so all these are, in a sense, not so good towards something as fundamental as privacy. Okay. Okay. So I think there's enough said about these 3 points. Number 4, let's number 4. Okay. The 4th comment on page 3 now is that this judicial activism is such that it is jurisdiction specific, and that itself is also not good. Because in consequence, the law may develop through the courts in England, but there's no effect on other parts of UK, such as Scotland and Northern Ireland. So my point 4 is that the laws developed currently are specific to its jurisdiction. It is only applicable for now to England. But you know, of course, that UK is not just England. UK is England, Ireland, Scotland. The current laws we have is such is only applicable to England. As a result, therefore, increasingly, we are seeing now a different framework. So therefore, it's even now more fragmented. Earlier word now. But in relation now to different jurisdictions. So depending as to whether you are someone living in Scotland, Northern Ireland, or England, you may or may not have privacy. That's really terrible. Okay. So the call for a statute is good. To make a statute that says it's applicable across the board, okay, to UK, as opposed to just England, right? The current laws are for the England. Again, you know why? Because we're dealing with an equitable principle. Equity cannot be applicable across the board, right? In the whole of UK. So for now, it's only applicable to England. And so for this point, is why it's also a negative point. One last one, about 5. Is this. With expanding common law that becomes fragmented, there's also the issue of certainty and accessibility, which makes it difficult for a lay person to understand his or her rights. Okay? Which my earlier comment here, okay? Difficult for individuals to access their rights. So here that you find that there is a lack of certainty, a lack of predictability. You can't predict what the laws or what your rights will be. And also, the main point here, of course, accessibility. People don't know these laws. In fact, let's say now as an example, your grandmother's picture was taken. It appears in a magazine. And it could be because she's a very good cook. And so someone took a picture of her and featured her alongside other cooks in Singapore, good old-fashioned grandma's cooking. So picture is there. It may well be that you are proud of your grandmother. It may well be that to me, a reader, to many of us, a reader, we think, oh, very good. But to your grandmother, she may not like it, am I correct? I don't know. She's a very private person. Or she thinks that, oh, that picture taken shows me with so many wrinkles and I look so old and no makeup, my hair was not combed properly, I don't look nice. But it could be, of course, for the photographer, they took that picture deliberately to show her like that old auntie kind of thing, But your grandmother wants to be the sexy, glamorous grandma, maybe. So anyway, she's not happy, she's not happy. She wants to sue. Now, she asks you, hey, you studied law. Hey, do you get this? When you study law, you have people asking you law questions. All the time, right? And can you answer them all the time? So you say, Mr. Trump didn't teach me. No. So anyway, people ask us law questions, and we can't give the law answer all the time. It could be an area we never studied, fair enough, or an area that is not really in the syllabus anyway. And even if we study or in the syllabus, law is so wide. We cannot be expert in everything. And so now grandmother comes to you, hey, you study law, right? Tell me, this picture taken without my consent, do I have any privacy laws to sue? And guess what? You have no choice because you know the law, right? You say it depends, am I correct? You may say yes, you say no, I don't know what you say, but the point is that all that, Murray, Hanover, rock and roll, PJS, would she understand all these things? Article 8, Article 10, all these 5 factors, 7 factors? No, she would understand. Public policy. What policy? To her, it's very simple. I never consent to the picture being taken or published. It can't be. To her, it's very simple, You tell her that it depends on the facts, on a case-to-case basis. She will understand that. To her, you never ask my consent, you can't do this. In fact, it's true. I frequently speak to laypersons, and they always say to me, hey, Mr. Trump, this is wrong. Invasion of privacy. Think about it. In Singapore, is there any Privacy Act? Any thought of privacy? What invasion of privacy? The only law we have in Singapore, even UK, is BOC. The BOC is what? Confidentiality, not privacy. So the thing is, laypersons think they're privacy, but that's not true. There's no privacy. There's no thought of privacy. There's no Privacy Act. The only law we have that's closest is confidentiality. And even so, confidentiality is not privacy. If you choose to take off your clothes in public, like rock and roll, what confidentiality? Nothing confidential. And so for that's why you find that the law is very uncertain and it's not accessible, not user-friendly, right? Not intelligible to the layperson. Okay? Any questions? So this is the first part of the answer. Before you take a break, let me just finish this first part. On page 3 now, the second half of the answer is where we're going to talk about reforms and the recommendations made by the Commission. This is your ECHRC. And so on page 3, under the heading of recommendations, it now says they make 3 recommendations. Number 1, they are saying that there should be a clear set of privacy principles. Yeah, clear set of privacy principles. And they are advocating a principles-based approach versus a rule-based approach. I'm not so sure whether you jurisprudence study this or not. The difference between principle-based laws and rule-based laws. Do you know this for jurisprudence? Or in any law for that matter? Yes? Company law, for example, we touched on this briefly. A rule-based approach, like the term suggesting that you a rule-based, is like these are rules 1, 2, 3, 4. Do you follow or comply? Rule-based. No, they are saying no. It should be a principle-based approach. Privacy principles. Okay. they focus on, they are advocating for principles, as in, we want privacy laws to achieve these principles. And so how you get there, it depends. In that sense, there's flexible. Okay? So this allows for flexibility. But at the same time, although it's flexible, it's also very clear. There's also a degree of certainty. Rule-based to be clear. But once rule-based approach is clear, it's very rigid. Let me give an example. Okay? Say in the context of studying. Okay? How to study? A rule-based approach to studying is this. Study 2 hours every day. Study in the morning when you're most fresh, 7 to 9. In between the 2 hours, have a short 5-day break. Rule-based, okay? The rule of studying. Rule 1, rule 2, rule 3, rule 4, rule. Make sure that there's no music and no loud noises in a quiet room, okay? But what rules may work for one person will work for another. For example, can you study in silence? You can. Can you study with music? You can't. Can you study with music? You can't. Can you study with music? It depends. No, not serious. No, yes or no? Depends, is it? Okay.
Depends on music.
Okay, no, whatever is your favorite music.
It depends. When I'm reading random music, when I write charts and all that, I need to.
Oh, is it? Oh, okay.
It's like a repetitive.
Okay, good. Even by what you say, already tells me or tells us that a rule-based approach to studying won't work. If honestly, with many of you, I can't study with music. Whether chart or studying or reading, I just can't. I just need to have silence as me. But I do realize also that this is the different generation. The younger ones, they can't study without noise. Is that right? They can't study without noise. They have to have noise for some reason somewhere. But again, okay, it's different generation in a sense. But my point is that what rule may work for me won't work for someone else. And this is why rule-based is, while clear, while certain, it's rigid. It's not effective in a sense. Compared to now, my same example, let's not have rules to study. Let's have principles to study. So for example, the principle is this. Make sure it's a conducive environment. That's the principle. By conducive, it can be with music or without music. Study at an appropriate time that you're most alert. It's the principle. If it's 7 to 9 for some, it will be 2 a.m. for others, am I correct? Make sure your studying is in with period of study with intervals for rest. Whether it's 2 hours or 1 hour, whether your rest is 5 minutes or 50 minutes, up to you. So we have that objectives with a principle we to achieve. How to achieve a principle, up to you. One other way to explain the contrast between principles and rules is this. Principle is say, this is the end. How you get there, up to you. Rules will give you now the rules to achieve that. The end is the same. We want to achieve privacy. But we want to achieve privacy by letting you know what the end is or what the rules are. And so the Commission is now recommending it's not using a rule-based approach, use a principles-based approach. The idea is this. The law now is very fragmented, am I correct? We have Article 8, Article 10, newspaper, freedom of press, individuals, 14-year-old boy, children. There's so many things that we have to factor in. At the end of the day, let's just get it right. What are some underlying principles that we want to achieve? And then with those principles determined, then how we get there on a case-to-case basis. Then we'll achieve now flexibility, yet with certainty. Okay? The problem now that we have is this, right? Currently now, let me add one point. You will also provide an overall or an overarching framework. So there's a need to provide an overarching framework, which currently we don't have, right? Which is lacking. Currently. Let me explain what I mean by this overarching framework. We know, for example, that we want to achieve privacy. This is the goal, so to speak. But what is the overarching principle? What is the foundational principle of privacy? For example, is it that we want to respect the rights of individual citizens? Is it individual privacy? What about with collective privacy? And sometimes, even if one person does not have privacy, but so long as a group collectively, someone in your position, in your shoes, in your category of persons have privacy is good enough. Or, for example, now, what about the role of the state? The fact that they also need to know about you and get from you information to use it. What about, for example, freedom of press, where they also need to be able to use information to sell newspapers? What I'm saying is this, that currently, different cases have focused on different points. Some cases will say, oh, press is important, publicize. Some will say, no, this person's individual's rights have been compromised, let's protect. Some other cases, no, collective privacy. Okay. And this point, different cases seem to have a different end objective. And therefore, they will have different principles developed or different rules developed to achieve the end. What we're now saying is this. Let's have a coherent framework, right? We are able to build an overarching framework that's coherent, right? We know exactly what we want to achieve. As opposed to now where we are being pulled at different directions on a case-to-case basis. Okay, so all this I'm explaining now is in your notes somewhat, but I've added some other words for you to understand what point 1 is. Point 2. Point 2 is like a second phase or second part of the strategy, which is where we then want to look at existing legislations, to reform the existing legislations. So number 2 is to review or to reform existing legislations. And the idea is to make sure that we can reflect or achieve point 1. Okay? So now that we have point 1, we have a clear set of framework or policies or principles to follow. Then number 2 is to review all legislations to make sure that we abide by those principles. Okay, that's important. And number 3, the last one, is to have greater regulatory coherence. Okay, greater regulatory coherence. To make sure that every other law that we have or will have, present or future, are all coherent in achieving what? The same thing. The principle. So this is really the part that's most important, okay? Number 2, number 3 come later to reflect number 1. Let me give you an example now. We know, for example, that if, let's say, we have taken information from you, it has to be safeguarded. But the thing is this, different purpose, different organizations, different contexts, currently, that information is safeguarded differently. For example, if today you apply for a passport, you're given to the government your photograph. Okay? Now again, it's given for a particular purpose to make a passport. Now, can they keep your photograph for other purposes? And if so, for what other purposes? Another example now, the police. It could be that they are doing investigations and they take a photograph of you. The thing is this, I don't know about Singapore, but in UK, they can't keep it for beyond a particular period of time. After a certain period of time, they have to destroy the photograph. They will destroy the information because why? Why are they keeping your photograph for no reason, right? But when it is for how long? 2 weeks? When the case closes? What if the case never closes? Different government agencies have different rules. So maybe for immigration, they keep for 2 weeks. Police keep for 4 weeks. MOM keep for 6 weeks. Example. That's my point, there's no coherence. Right now, every department, every agency, every company, public or private, have different rules on how to take privacy. What about Singtel? What about StarHub? Now, of course, they don't have a picture per se, but my point is this, your name, your phone number, your address, the extent to which they keep your records. Now, if you are a customer, sure, they can keep it. What if you have a change line? The moment you know about a subscriber with Singtel, can they keep your data? I'm sure they do, but they should not. But what law says they can't keep it? And even keeping it, how safe and how secure? Some say I keep it in a file. Some say, oh, keep it in soft copy. Some say it's encrypted. Some say password protected. I mean, the extent of privacy that you are getting currently, or we are getting currently now, with different companies, on different matters, with different agencies, all different. That's it. There's no coherence in privacy. How can privacy laws be safeguarded unless and until we have a statute or a law that prescribes now these privacy principles? You say, but we do have privacy in common law. That's my point. Common law is weak, piecemeal, fractured, not accessible, not user-friendly, inconsistent. This will overcome all those problems. Okay. Now, I'm not saying that this has to be your conclusion, but at the very least now you appreciate more or less what the commissions argue, and I think to some extent they are not wrong. Okay? Any questions? Now we'll take our break now. We come back. Look at now page 4 first. We'll still look at privacy but from a different angle. What I've not yet touched on so far will be the development of two particular cases. One is a case called Vidal and Google. The other is a case of Ray PJS, which I mentioned briefly just now. Right? We're going to review these two recent cases because those two cases effectively actually has gone against the Commission. As in, they've not gone down a path of the Commission. The Commission is clearly saying what? We must have a statute. We must have a legislative framework of principles. This is what the Commission recommended. But currently in UK, do we have that? No, we don't. On the contrary, in UK, we have somehow taken the opposite direction. We have expanded common law. We have expanded common law to now expand BOC to protect privacy, to create a new thought of privacy. So when we come back after the break, this will be the focus, which is this expansion, is this development via the common law route, using or creating a thought of privacy, is this a step in the right direction? Okay, let's take a break and we'll continue after this.